So picture a painter. Let's call him Subramani, working high up on some scaffolding for Iron Builders Private Limited.
Okay.
Suddenly he falls, and he sustains some pretty serious injuries. But there's this really critical detail here. He wasn't wearing his company-provided safety belt.
Right. And that single missing piece of safety gear completely changes the legal reality of what happens next.
Exactly. So looking at the stack of legal case files and statutory notes you sent us for today's deep dive, our mission is to figure out exactly when an employer is liable for workplace accidents.
Yeah, and how one specific outcome can basically completely reverse a court's decision.
Right. So where do we start with Subramani?
Well, the baseline here is the Workmen's Compensation Ordinance number 19 of 1934. Under Section 2.1, Subramani is officially a workman.
Okay, which means he's eligible for compensation.
Exactly. Normally, Section 3.1 applies strict liability to employers. So if a worker gets hurt on the job, the employer generally has to pay compensation for their lost earning capacity.
Right, and we saw this in the Ratnapala case, right?
Yes. Ratnapala versus Sri Lanka Co-operative Industries Union Limited. The courts reinforced that, minor technical mistakes by a worker won't automatically cost them their compensation.
But Subramani didn't make a minor mistake. I mean, he willfully ignored a major safety rule by ditching the harness.
Right, which triggers the exception. Because he survived but willfully disobeyed a safety rule, Section 3.1b activates.
Ah, so that introduces contributory negligence.
Exactly. The worker's own actions actively contributed to the injury. Because he blatantly disregarded the safety gear, the law gives the employer an out. Iron Builders Private Limited is completely exempt from paying.
Wow. I mean, well, it makes sense. It's kind of like voiding a product warranty,
How do you mean?
Like if you take a brand new smartphone, completely ignore the manual and go scuba diving with it, you can't expect the manufacturer to foot the bill to replace it.
Right.
You explicitly ignored the safety rules. You break the rules, you break the device, you absorb the cost.
That's a great analogy. The legal system actively holds workers accountable to enforce safety standards on the ground.
Okay, but let's shift gears for a second. What if we change the outcome of that fall? Let's say Subramani didn't survive.
Well, then the legal machinery reacts very differently. Even though he still broke the exact same rule and still left the safety belt behind, the employer's defense just vanishes.
Wait, really?
Yeah. According to the landmark judgment, Daniscotti Thivar versus Michael Fernando, the safety defense under Section 3.1b is entirely overridden in fatal accidents.
So the contributory negligence part
It vanishes, making the employer strictly liable to pay the deceased worker's dependents.
Wait, I have to push back on this. That feels, isn't that entirely contradictory?
Sounds like it, sure.
Like, why does the law let the employer off the hook if the worker breaks a leg, but makes him fully liable if the worker dies making the exact same mistake? The root cause, the missing safety belt, it hasn't changed.
It looks contradictory until you examine the underlying philosophy of that Daniscotti Thivar judgment. In non-fatal cases, the law's priority is penalizing negligence to deter unsafe behavior.
Right, to teach them a lesson.
Exactly. But in fatal accidents, the worker is gone. You can't penalize them anymore. So the focus immediately shifts to their highly vulnerable dependents.
Oh, wow. Okay, so the law is essentially deciding that a grieving family shouldn't be left completely destitute just because of a worker's, momentary lapse in judgment.
Precisely. The loss of life shifts the financial responsibility right back to the company. The burden of strict liability transfers back to the employer to protect the family.
Whether you're managing a job site or working on one, this has massive real-world applications.
It really does. And beyond the immediate safety protocols, there is a strict legal clock ticking on all of this.
Right, the timeline under Section 16.1, which was amended by Act Number 10 of 2022.
Yes, any compensation claim must be initiated within 2 years of the accident, or 2 years from the date of death. The legal system offers substantial protections, but they are absolutely bound by that window.
So if you miss it,
the opportunity for compensation dissolves completely.
Man. We started by picturing Subramani on that scaffolding and saw how one missing safety belt dictates a legal outcome. But seeing how the law flips to protect dependents, it leaves you with a really heavy question to ponder.
Yeah, it does.
Does stripping the employer of their legal defense in fatal accidents unfairly penalize a company for a worker's human error?
Right.
Or is it a necessary burden, Something designed to force companies to relentlessly enforce safety rules on the ground, ensuring that safety belt is actually fastened every single time.